welcome you all on this very important seminar. I think this is the 21st seminar being organized by MSWA and Rotary Club of Bombay West. The topic is very important. It is regarding transfer of holding, flats, shares and interest of the deceased member in a cooperative housing society. Before I come to the topic per se, let me throw some light on the issue of the object or the purpose of the nominations which is being provided. By and large, for any property, any financial investment such as mutual fund, shares, bank account, public provident fund, labor laws, everywhere almost a nomination is provided. And therefore, in nutshell, let me tell you that nomination is for the purpose of facilitating the entity to recognize a person to deal with in case of death of the member, death of the employee, death of the investor. In our case, in housing society, death of the member of the society. So the society's work is facilitated, it is simplified. For that, there are the provisions under Maharashtra Cooperative Housing Societies Act. Let me tell you, prior to the amendment effective from 9th March 2019, when the new chapter was added to the Maharashtra Cooperative Societies Act, Chapter 13B, the provisions under Section 30 were applicable to housing societies. Let me clarify that as of today also Section 30 does exist in the Act. However, it applies to all other cooperative institutions except the housing societies. Because for housing societies, in Chapter 13B, Section 154, capital B, 13 has been specifically introduced for the purpose of succession of property or holding and the shares and interest of the deceased member in a particular housing society. It will not be misplaced to first tell you as to what was that Section 30 and what is the new provision. When we study the comparative aspect, it will be much clear to us because our thought process will look into both the aspects as to what is the change effected from 9th March and what are the provisions prior to that under Section 30. As far as Section 30 is concerned, let me tell you, when a person in a cooperative housing society, when a member expires, as per Section 25 of the Act, he ceases to be member of the society automatically. Now, when he ceases to be member of the society, it does not mean that his property is less. His property is very much there in his name only. However, we have to admit his legal heir or legal representative as per the succession provisions applicable to that particular member. It's a personal law. If he's a Hindu, then Hindu law. If he's a Mohammedan, then the Mohammedan Act. These provisions, whoever is a legal heir of the deceased will be admitted as a member of the society. However, till the time such admission happens, till the time such member is admitted as the property is transferred to him, it may so happen that there is a long gap or there can be a dispute. There can be waiting for the court judgment. So to facilitate the cooperative societies to recognize a person, the provisions of nominations under Rule 25 of the Maharashtra Cooperative Societies rules are existing in the Act and the rules. Now, what are these provisions? During the lifetime of a member of the society, he has to file his nomination with the secretary of the society. The secretary has to keep it on record. He has to pass a resolution in the managing committee, and he has to maintain the nomination register in the society. Having done so, the member is said to have nominated someone to whom the society will recognize in the eventuality of death of such person. And therefore, as you can understand, in case of absence of nomination, how much problem the society will face, even the legal heir of the deceased will face. Having given the overall idea about the concept of nomination, the object of nomination, and a summarized form of the provisions in the Maharashtra Cooperative Societies Act and the rules, let me now come to the substantive law. Now, substantive law, as I told you in the initial stage, that Section 30 was applicable to the housing societies up to 8th of March 2019. After enactment of the amended provision in the form of Chapter 13B, which also includes section 154 capital B 13 for transfer of shares or interest of the deceased member to a person. Section 30 is very specific. It says that in case of death of a member, the legal heir of the deceased will come in the second limb. In the first limb, the nominee will be admitted as a member of the society. For that, the bylaws of the cooperative household societies, the model bylaws included bylaws number 34, which said that when the nominee of the deceased apply for membership following the provisions of bylaws number 34, such nominee shall be admitted by the committee, mind where not the general body meeting, by the committee as a member of the society, and the shares and interest of the deceased will be transferred to the nominee. However, friends, as I told you, this is not transfer of the property, the ownership of the property. This is a stopgap arrangement till the time the legal heir of the deceased are inducted. Now, presuming for the sake of argument that there is no nomination, then again what will happen under the old provision? Under the old provision, in absence of any nomination, the ball was in the court of the managing committee, and in the opinion of the managing committee, whoever is the legal heir of the deceased will be invited to apply for the membership of the society. He will be admitted as a member, and then the shares and interest of the person will be transferred to him, not the ownership. Now, new provisions are in effect the same. However, the procedure is little bit changed. Section 30 starts with the provision that nominee comes in picture first, and in absence of nominee, the legal heir will come in picture. Exactly in opposite position, section 154B13 says that the legal heir of the deceased shall be admitted. However, the first proviso of that section says that if there is a nomination validly filed by the deceased member, then in that case, the nominee will first be admitted as a provisional member, and then following the other provisions, as and when other documents are produced by the legal heir, or as and when the legal heir come forward, or the court judgment comes in case of probate, the legal heir will be admitted. Now, there are a few very important aspects. First of all, under the old provisions, the cooperative housing society did not have the authority to look into the will. The society cannot take cognizance of the will. So, therefore, only two documents were accepted by the societies, that is a succession certificate and the heirship certificate. As far as the new provisions are concerned, the law has stated and listed four kinds of documents. The first one is the any testamentary document. As we know, testamentary document is the will. The second is succession certificate, third is heirship certificate, and the fourth very important document is the family settlement agreement. And therefore, now the society is enabled to accept any one of these documents. Now, many questions arise. The legal views, opinions may differ, but I am of the firm view that family settlement agreement, or for that matter, even the will, need not be registered because the law does not require them to be registered under the general law, and therefore the society will accept those documents. Having admitted a nominee as a provisional member, the subsequent procedure is to be completed by the society on application. For that, the society has to accept, take cognizance of the testamentary document, that is a will, or the last document, the fourth one, that is called the family settlement agreement. Let me tell you, the submission of this document per se will not automatically entitle such person to be the member of the society. There has to be a procedural aspect. Under section 30, under the old bylaws, there was a provision 35, under bylaws 35, which provided as to how the application will be made by the legal heir of the deceased. As far as the new provisions are concerned, under second proviso to section 154B13, the rules are yet to be prescribed by the state government for the purpose of prescribing the manner in which the legal heirs will come forward for the purpose of admission. So we are waiting for the rules to be prescribed. But in nutshell, as I told you, the nominee will be admitted as a provisional member, and subsequently the legal heir or the person entitled to the property as per the will of the deceased or as per the personal law will come in picture. Here, friends, three aspects I would like to highlight. One is the definition of person, which has been largely widened under the new provision. Section 134B1, subsection clause 20 has prescribed the new definition of person, wherein a large category of persons have included. It is very important to note down that the HUF, which was erstwhile provision did not allow it to be a member, can now become member. A private trust, a registered or unregistered trust, an association of person, limited liability partnership, any other legal body which can hold the property can also become member, as well as any other entity as may be notified by the